Welcome. This is a video on a lot of different topics relating to estate and trust administration. Um, and not all of these topics are addressed in the materials. I would encourage you to take notes as well. A copy of these PowerPoints have been posted to Blackboard that might help you out. All right, so let's get going here. I'm going to cover probate, trust administration, and fiduciary income taxation as broad topics, a lot of specific topics. Just kind of a review on probate. What are the processes of probate? Probate is a court proceeding. It is done typically by an attorney representing the executor or personal representative, filing a petition for estate administration. There's an order admitting the will to probate, and in most states there is something called letters of administration that are issued. Here in Kentucky, it's called something different. And then after basically the probate is open, there's a lot of things that have to be done. An inventory has to be filed with the court. There has to be a notice that is actually sent by mail, usually return receipt requested, to all the known creditors, people who are owed money, because they have to file claims against the estate. And then there's a notice to unknown creditors that's published in a newspaper of general circulation. And there are actually newspapers that are actually specific for publishing legal notices. And then all the assets are collected, things might be sold off if necessary, if they're not going to be distributed. Bills are paid, fees are paid, income tax returns are filed, and then finally there's a final accounting, a report of the personal representative that is filed, and distributions are made. Most of the time, beneficiaries waive what's called the formal final settlement, which is kind of requires a hearing on that, a notice of final settlement. And then eventually there's an order closing the estate. All of this can take 6 to 7 months at a minimum. It's not uncommon for it to go more than a year, and sometimes for several years, depending upon the complexity of the estate. Yeah. So here's just an example of the notice of an appointment of an executive here in Kentucky. Somebody from Russell Springs for the estate of Elvis Tucker back in 2017. Here's a notice to creditors that was published in a newspaper as well. And here's a notice of filing of the final settlement. Now, this is where basically there's not a waiver of the final settlement hearing that you would typically see. So just some kind of examples there of things to do. Little note here on how to deal with safe deposit boxes. And if the decedent is the only registered owner of the safe deposit box, you need a court order to prove that you can get into it. So basically, to gain access to a box, you have to file and get basically the judge to sign an order allowing somebody to get access to the box. Obviously, that's not a very good thing, especially if the will is located in the safe deposit box. So it's usually a good idea to advise clients to put a safe deposit box, have somebody else's name on that so that the surviving owner will have access to the box, obviously a trusted person. All right. Here's an example of letters of administration. Now here in Kentucky, they just have an order admitting will and appointing the executor. And that takes the place of what are called letters of administration. But what you'll see when you're dealing with brokerage accounts and the like, when somebody dies and it's just an account in their name, not an IRA account, but just a regular taxable account, then what they'll typically require is letters of administration for the executor or personal representative to basically become the person who has authority over that account. So they'll ask for a certified copy of the letters of administration. Same for bank accounts. Here's a certificate of qualification. Yeah, just another Kentucky form. When there's real estate that's held by an estate, you typically see a personal representative's deed. That's almost always prepared by an attorney, signed by the personal representative, also called executor. And deeds, of course, are recorded in the public records. When you're dealing with real estate that is held by a trust, it's a trustee's deed, very similar. So here's an example of an executor's deed. Just looks like a typical warranty deed, but it just has a little bit of different language in terms of basically here under the direction of the last will and testament, the grantor, who's the executor of the estate, in this case executrix of the estate, has the full right and power to transfer the property. Yeah. So another thing is ancillary probate. Uh, if you have real estate that's located in another state, you end up with probate not only in the state of residence of the decedent, the person who passed away, but also you end up with probate in the other state. So you end up getting an attorney who has to get a what's called an exemplified copy of certain documents in the original state, send them to an attorney in another state who then has to open up another probate proceeding there. So it gets kind of complicated. So when you have clients who have real estate located in another state, it's a good idea to try to avoid probate. And usually the ways of doing that is to have that real estate located in a revocable trust. Another way of doing that is to have the real estate owned by a limited liability company, which might give some asset protection features, which we'll talk about later. So we have all these different ways that property can pass from a decedent to another. Life insurance, IRA accounts, 401ks, annuities, all of these can have beneficiaries on them, as well as bank accounts and brokerage accounts, transfer on death, pay on death accounts. Also, a type of bank account called an in trust for account is also referred to as a Totten trust account. It's kind of the old form of pay on death or transfer on death. It's been around over a century, but sometimes you'll come in contact with those. But most of the time, it's transfer on death or pay on death. You also have joint ownership with rights of survivorship. One owner dies, it automatically goes to the other. The husband and wife version of that is tenancy by the entirety's property, which I think in about 15 states have tenancy by the entirety's property, usually with regard to real estate, as here in Kentucky. But in other states, it can also apply to personal property, and there's some asset protection features there. Tenancy in common, again, is owned like there's 3 tenants in common, each owns 1/3, and when one dies, it's not with the rights of survivorship. Just as a reminder, that 1/3 interest still has to go through probate in that case. Probate occurs for anything passing under the will. It doesn't apply to things that have a beneficiary. It doesn't apply to joint tenancy with rights of survivorship or tenancy by the entirety's property. And it doesn't apply to property that's held by a trust, because the trust will dispose of that property. We'll have the instructions for doing that. So it's nice to avoid probate. It's nice to avoid all the delays and the attorney's fees and costs of all probate. Yeah. So what is a revocable trust? Basically, just a real summary here. Here's basically what a trust says. I create a trust. I'm the trustee. I will name a successor to myself, usually a family member. I can change the trust. I can remend it. I can revoke it. That's why it's called a revocable living trust. You do an amendment to the trust to do that, or a revocation of trust. I can add assets to the trust by putting them into the name of the trust, or I can take them out at any time. But basically, I have complete control over everything. And if I become incapacitated, I can use the trust assets for my care and also for the care of my spouse and dependents. And then it says, upon my death, basically what you would see happen in a probate, but without the court proceeding. Collect all the assets and already name the name of the trust, pay the bills, pay any fees that are due to the trustee or attorneys or accountants, pay taxes, and then distribute the assets as according to the terms of the trust. Now, a lot of trusts, you'll see assets held in trust, not immediately distributed. For example, provide for somebody's maintenance, education, support, and healthcare. And that's some pretty common language to use. We refer to it as a mesh distribution. It has some income tax aspects of it. Why that language is used for income tax purposes, if somebody's the trustee and can distribute to themselves for their maintenance, education, and support and healthcare, or to somebody that they have a duty to support, like a child, they're a parent of a child, then by using just that language and not a whole bunch of other language, you make sure that they are not treated as the owner of that property for income tax purposes. And a very common distribution, most attorneys nowadays will draft like 1/3 at 25, a third, half of what's left at 30, and then the rest at 35. I typically go a little bit further than that, at least in terms of what I recommend to clients. because most people under the age of 30 really can't handle money. Of course, you make sure that they're educated and any needed support until that basis. But when do they get the bulk of the assets, especially in a larger estate? So a little bit more on estate and trust administration. We need to value the estate's property. Why? Well, we need to, one, establish a new cost basis in the property and make sure our inventory that we file within a court in a probate proceeding, and also to be fair to all the beneficiaries. So we want to make sure that distributions if we're distributing property are equal. Right. So here's an example. Bill Paxton died in February of 2017. And we'll just assume that he owned 1,000 shares of General Electric stock. Now, his death occurred on a Saturday. So we have to take the average of the values for Friday and Monday. And how do we do that? Well, we can go back and actually search online for Market Watch historical price quotes. And you can actually get the historical prices of stocks this way. And we take the high value and the low value on both Friday and Monday. We take the average of the high and low on both days, and then we take the average of the above. And by doing that, we see that the high value on that day and the low value on that day, we come up with an average. Then on Monday, we come up with an average, and we take the average of Friday and Monday, and we come up with $30.005 per share. That becomes the new basis of the stock. So from that point forward, if the stock is sold one day later, let's say it was sold on Monday, 227, the basis would be $30.005 per share. That determines any capital gains or capital losses from that day forward. So Bill purchased 1,000 shares on March 6th for $7 a share. If Bill sold the shares before he died at $30 a share, what would be the capital gain? Well, let's go back here. We'll say he purchased it March 6th of the preceding year. So he died on a February 25th. It's not quite a year. All right. So if he sold the shares before he died at $30 a share, the capital gain would have been 30 minus $7 a share times 1,000 shares, 23,000. If he owned it for more than a year, which is a year and a day, it would be a long-term capital gain. Otherwise, it's a short-term capital gain. The tax on long-term capital gains can be zero if somebody's got a really low income tax bracket. It can be 15%, which is probably most people. But when you get into the higher income tax brackets, you're going to get the 20% long-term capital gain rate plus a Medicare surtax of 3.8%. So you're going to be at 23.8%. That's going to be better than the ordinary tax rates, which in that range are typically going to be in the 28 to 37% range or so. We also have to be careful about alternative minimum tax implications sometimes. All right. So now if the executor, after Bill died, Bill's estate sold the shares a week after he died at $31.05 a share, what would it be? Well, we've got this new cost basis. So here, the stock had gone up in value by $1 a share from the date of death. And it doesn't matter how long the stock was owned at that point. At death, any sale of the stock after death is treated as a long-term capital gain or a long-term capital loss. So here we only have a $1 share gain, and that's treated as a long-term capital gain. And assuming he's got a large amount of assets, which would trigger basically tax at 23.8%. So how do financial advisors handle all this stepped up basis? Well, fortunately, we have custodians, we have brokerage firms that hold the stocks. And the law now requires, it used to do this 10 years ago, but now it requires that brokerage firms get a certified copy of the death certificate that verifies this is the date the person died and set the new basis. Basically, they record the basis of the stock. They are required by law, tax law, to keep track of the basis of the stocks and other investment assets that they have. So as it used to be as a investment advisor, that we would keep track of cost basis and update our software, and the brokerage firms didn't do that. But nowadays, brokerage firms do that. And it's really simplified things because we don't have to go up and look up all the values. The brokerage firms do all the calculations for us. If the individual account, once it's converted to that estate account, the personal representative will possess control. Again, you submit letters of administration to do that. So here's just another example. Now, this is for a mutual fund. Let's say Bill owned 512,000 shares and plus some others, Vanguard 500 index fund. The Friday value, what we're looking for is the value at the close of trading and also the Monday value because he died on a weekend, and we take the average of that. So when for open-ended mutual funds, we're taking the value at the end of the day on the date of death. And if it's a weekend, we average the Friday and Monday. Or if it's a holiday, like a Monday, he died on a Monday that was a holiday, the stock markets weren't open, we would still take like the Friday and the Tuesday value average, right? So there is another date that can be used that's called the alternative valuation date. It's 6 months after the date of death. We can use that as an alternative valuation date, but only if it lowers the amount of the estate tax. And the estate tax exemption, as we'll study, is really high right now, over 12 million. So this is not going to apply to a lot of people. It will only apply to very large estates where the value of all of the assets basically has declined over a 6-month period. And this basically reduces the estate tax for someone. And the estate tax rate is 40% above whatever the exemption amount is. So you're saving a lot more here than you would in terms of having a stepped up basis and saving potentially 23.8%. All right. So just an example, GE stock, date of death value, but 6 months later, it had declined to $24 a share. I'm just assuming this. The reduction in value was $6,000. That saved $2,400 in federal estate tax. Now, when you have a probate estate, typically you also have a checking account. You actually open a checking account in the name of the estate, like the estate of John Smith, and it's opened by the executor. We'll say Mary Doe is the executor, and any checks received are deposited to the account. Now, quite often, attorneys' offices will have paralegals who work on probate, and the paralegal will get any bills from the personal executive to be paid and get any checks to be deposited. Basically, the lawyers are very protective. They don't want the executor to make mistakes because then they have to explain to the judge, hey, I didn't give right instructions to my personal representative. So a lot of times they'll have paralegals who basically take control of the checkbook so that individual executors who don't know how to deal with these things don't make mistakes. Yeah. So in a living trust, you don't need necessarily a paralegal to be involved or an attorney to be involved. Usually there's some advice given, but typically it's the trustee who's doing that. Again, if there's a home inside the trust, you're going to have a trustee's deed, bank accounts and brokerage accounts. You hope that all of these things are already titled under the trust. Life insurance could have the trust as a beneficiary, and as we'll study, IRA accounts can have a beneficiary as a trust as well, and similar types of accounts. So this trust funding process is something that's often the financial advisors assist the client with all the accounts that they have, typically brokerage accounts and the like. And we follow the instructions that we are given by the client or the client's attorney. We don't tell the client, hey, this ought to be in the trust, or you ought to name this person as the beneficiary. We're following the instructions that we're given when we do that. We're preparing new account forms and account transfer forms and the like. Yeah, so we help with that process. Yeah. So what happens if the creator of the trust becomes incapacitated? Well, the trust is still going. This is a living trust, all right? John Doe, we'll say, is the trustee. The successor trustee often tries to secure, a lot of times in these trust agreements, it said, someone's deemed incapacitated if a physician puts in writing that the grantor no longer has legal capacity. Well, most physicians don't want to do that. I mean, they're not a committee. Then they don't want to say that somebody's incapacitated because the test of incapacity, there's lots of different tests for different purposes. So most physicians don't really want to get into preparing letters like that. It's usually better to say that a committee is formed in the document. It names three people, perhaps family members, that would determine whether the grantor has capacity or not. And sometimes an attorney might be on that committee or something like that. A lot of times when I hit this situation, when somebody gets to the point of incapacity, I just go and visit them as my client usually, and I have them resign. I have them sign a statement that they resign as trustee. It's just a lot better than trying to get if it's just a statement of incapacity, or even, having a committee do that. And usually the clients by that point will go along with it. Of course, if somebody, had a stroke and is unable to sign, you really can't go through that process. All right. So in this case, we had a new successor trustee, Josie. So Josie Doe becomes the trustee of the John Doe Revocable Trust. And again, we had to have new account forms signed. Now, sometimes it's just changing the name on the account, like the name of the trustee, and the same account number is used. And then some brokerage firms and banks will actually require a new bank account or something like that, or a brokerage account. So when someone dies, again, we get certified copies of the death certificate. I usually tell a family member, who's ever the executor or trustee is, to order at least 10 copies. And if it's a very large estate, we might order a lot more. 10 certified copies of the death certificate. It usually takes, couple days for the death certificate to be filed with the state, and then several days to get certified copies. And we get those certified copies and we use them for, like, submitting them to get life insurance beneficiary, to get the life insurance, to prove that somebody died for life insurance claiming, but also to get new account forms signed. Sometimes an affidavit has to be presented that no changes to the trust were made. Sometimes that affidavit is signed by the successor trustee. To their best of their knowledge, there's been no changes. Sometimes it's an opinion letter by an attorney that basically, to the best of the knowledge of the attorney, this trust is valid and has not been changed. So depends on, there's different requirements for in terms of, getting uh, basically the successor trustee named on the accounts. Now, during someone's lifetime, there's just a 1040 filed, and including when somebody's incapacitated, you just file the regular 1040, regular tax return. But after someone's died, and this is the case of John and Mary Smith, John died, you put at the top of the tax return, deceased John Smith, date of death right there. They're still filing a married filing jointly for purposes of that final 1040 for that year. Yeah. So they can file married filing jointly. Interesting enough, I had a client one time, husband and wife, the husband passed away probably right before, an hour or two before New Year's, uh, the New Year started. And I believe his wife waited a few hours before calling the paramedics to come and certify that he was dead. And then that actually helped her out a lot from an income tax standpoint, because she was able to file married filing jointly. Um, so again, here, instead of John being able to sign, Jane just says filing a surviving spouse here. And again, it's got the deceased John Stone and date of death up there. Yeah. So in that year of death, it's a good idea to get with a client, and there's usually estimated tax payments being made, typically by retirees. They don't have income, they don't have things withheld, so they have to make estimated tax payments. And it's usually a good idea to recalculate them so they're not overpaying taxes or underpaying them. Usually it's an overpayment because maybe IRA distributions are stopping or something like that. Make sure required minimum distributions were taken from the IRA accounts for that year. If someone died and had not made their required minimum distribution that year, that distribution is supposed to be made that year to whoever the beneficiary of that IRA account is. Um, so, or beneficiaries. So you still have to make that required minimum distribution if it hasn't been taken. Now, after someone dies, an estate or a trust files its own income tax return. So there's four types of taxpayers that pay income taxes: C corporations, individuals, partnerships, but also estates and irrevocable trusts that are what we call non-grantor trust. Now, again, when somebody's alive, they just file their regular tax return. Yeah, when John's the trustee, he files. If he has capacity, but let's say another trust company is serving as trustee, Pinnacle Trust Company. It's still his 1040. It's still a revocable trust. It's called a grantor trust. If he's alive but is incapacitated and his daughter Janie has become the trustee, it's still just a regular 1040 that's filed for him. So in all those cases, just a regular 1040 using John's Social Security number as the tax identification number. The reason is it's a grantor trust because John can revoke it or amend it or remove assets from it, or in the event of incapacity, it can be utilized to benefit John. So those are what I call the grantor trust rules for Internal Revenue Code purposes. And that's why it's a grantor trust, and a grantor trust is taxed as an individual would be. Yeah. So now if John dies, the trust becomes irrevocable. Kind of makes sense. You can't change the trust anymore, and it can't benefit him anymore. So it's a non-grantor trust. What tax return is filed then? It's a 1041. So very similar to a 1040, but there are some differences. And you take interest income and dividend income, things you would see, and then you take the total income here, and then fiduciary fees. You don't typically see that on a regular income tax return. And attorney, accountant, and tax return preparer fees, and then you get down to point of adjusted total income. And then you get to the point of income distribution deduction, because income that is distributed in a year out of an estate or a trust, that gets taxed to the beneficiary, right? And then we got down finally to the point of what the total tax would be. So here's the total tax based on the taxable income. This is after an income distribution. There's only $100 exemption. So, individuals have a standard deduction, $12,000 or $13,000 now, but states and trusts, there's only $100 exemption. So pretty much you get into a high tax bracket very quickly for estates and trusts. So you have, in this case, $38,000 of income that yields $8,000 of tax. And there were some estimated tax payments made, and that results in tax owing. So just a quick overview of that. Now, when someone dies, you have to get a tax ID number for the trust. Who you typically do? I usually get a hold of it if the taxpayer has an accountant or CPA. I email the accountant and CPA and have them get it. That's what they do. They're going to prepare the tax return anyway. Obviously, I want them to get a copy of the tax identification number back to me. The successor trustee can do that themselves. You can actually, as a financial advisor, if there is no attorney or CPA involved, you can sit down with them and go and get, pull up the IRS website here and get a tax ID number. By having them do it, you should not do it, but you can walk them through what to do. Yeah. And you have to keep in mind that there is some income tax planning that's done for irrevocable trusts and also for estates. The first $2,900 of income gets taxed at 10%, but then you immediately jump to this 24% tax bracket for the next $7,500 or so of income. And then you jump to a 35% rate and a 37% rate for income over $14,451. For long-term capital gains, remember there's a stepped up basis at time of death, but if there's long-term capital gains for an irrevocable trust, 10% for when it's taxed at 10% level, but then it quickly jumps up to 15% and 37%. This actually should be 15% plus 3.8. I wonder if that ought to be 20% plus 3.8. I think it is 20% plus 3.8. And that 3.8 is what's called the Medicare tax on investment income. Yeah. So tax planning, we want to determine what the trust's taxable income is likely to be. How much of that is going to be considered distributable net income? Now, this requires typically an accountant to help out because the definition of distributable net income can vary depending upon how the trust is drafted. Basically, it's income, interest income. It can even include capital gain income if capital gain income is considered distributable net income by the terms of the trust. And basically income that's distributed in a year is basically called distributable net income, which means the beneficiaries pay income tax on that income, not the trust. And that's usually favorable because trust pay can get to that high tax rate pretty quickly. So hopefully the trust permits capital gain income to be treated as distributable net income, especially trust that goes on for a long period of time. Otherwise, you can get capital gains tax at a higher tax rate than the beneficiaries would typically pay. Yeah. So, for example, here's a trust that has long-term capital gain income, short-term capital gain income, qualified dividends, non-qualified dividends, and taxable interest income. And let's say a beneficiary who gets 50% of the income upon receipt gets $20,000. How much of that is what? And you basically have to allocate that. You have to prorate that. And basically a Form K-1 is given to the beneficiary, and all of the income that is reported out is classified as either long-term capital gain, short-term capital gain, qualified or non-qualified dividends or interest income, taxable or tax-free. Uh, and uh, and on that income that's distributed, again, that the trust does not pay tax on that income. The beneficiary reports that on their own tax return using the K-1 to help them out. So unfortunately, until recently, we didn't have this rule about capital gains being treated as income up until about a decade or so ago. The trust written before 2014 really didn't have these provisions. So if you have long-term capital gains in a trust that doesn't have this provision that says capital gains can be treated as distributable net income, then any capital gains are going to be taxed inside the trust. You can't regard them as distributable net income. Unless it's the year of termination of a trust. And the year of termination of a trust, then all of the capital gains could be treated otherwise. So a lot of tax planning here, as typically for individual clients, we want to offset any gains during the year by harvesting losses. We want, for a trust that's going on for a long period of time, we want to invest not only prudently, but also tax efficiently. So we don't want things that are going to generate a lot of short-term capital gains and hopefully limited amount of long-term capital gains, at least first with regard to stocks, because trust can be into a very high income tax rate. If it's a large trust, we might look at municipal bonds for tax-free income as opposed to taxable interest income. So basically just following the typical rules on how to plan for tax efficient investing. Now, there's a difference between a simple trust and a complex trust, and I get asked this question as an attorney by accountants all the time. They said, "Is this a simple trust or complex trust?" Well, simple trust is required to distribute all of its income, and no amount is paid out for charitable contributions. So, otherwise, the trust is a complex trust, and so a lot of times it's a simple trust, but it basically this is something that accountants need to know because it depends. There's something called the 65-day rule for complex trust. If it's a complex trust, you have 65 days after the end of the year to make distributions and have them treated as income distributions for the prior year, but that's not available to simple trust. So that 65-day rule can come in quite handy, especially since you don't always know the amount of income to be distributed. Here's just an example. Mr. and Mrs. Bingle, married for 50 years. They have a net worth of $30 million. Upon Mr. Bingle's death, $11,580,000 was set aside in a family trust. That was a couple years ago. That was the estate tax exemption amount. It's higher now. Mrs. Bingle ends up with $18,420. Now, Mr. Bingle's trust basically says the trustee may distribute principal if needed, may distribute income. So this is a complex trust, doesn't have to distribute income. Capital gains are regarded as distributable net income. But Mrs. Bingle's got $18 million. When she dies, she's going to be taxed. Some of this assets are going to be over her exemption amount. I'm going to say $6,840,000 will be taxed at 40% for federal estate tax purposes. In addition, because of all the assets she's got, she's in a high income tax bracket to begin with and a high long-term capital gain bracket as well. Plus, she's going to have state income tax. Should this trustee distribute income from this family trust that Mr. Bingle set up, and should the trust distribute long-term capital gain income to Mrs. Bingle? And the answer is no. Why? Because one is you're not saving a lot in income taxes. You may only be saving 2% here. Maybe the trustee of this trust is in Tennessee where they don't have a state income tax. And maybe Mrs. Bingle's in Kentucky where for 2023, the tax rate will be 4%. So you're not really saving a lot of income taxes in that situation, and you're just adding to her estate. So anything you distribute out of the family trust to her, not only might it be taxed a little bit higher for income tax purposes, or even though it might be taxed a little bit lower for income tax purposes, you're basically just incurring an estate tax of 40% of that money when she passes away, plus any growth in that money. So it's a good idea to just keep things in the trust. Now, this relates to estate taxes, and we're going to study estate taxes after the spring break. Some charitable contribution planning. All right. So if somebody's going to give money to charity, all right, one of the things you ought to do as a financial planner is say, well, do you have any appreciated assets like stock in your taxable account that you can give instead? Because you can give stock to the charity, and a lot of times charities will have a brokerage account, or if it's a small church, you just set up an account for the church, and you have the client give stock to that account, and you have the church sell it and generate the cash, because churches as qualified charities, they don't pay any income tax. So you're giving away appreciated stock, you're saving income taxes that way. Wonderful opportunity to save money there. Now, what you'll more often see is for somebody who's 70 and a half or older and has IRA accounts, you can undertake a qualified charitable distribution. Charitable needs to be spelled correctly on the slide. It applies if the client is 70 and a half or older. Now, I know the required minimum distribution rules got changed to age 72 and then just recently to age 73 to 75, but for future years, but the qualified charitable distribution rule still says 70 and a half. So if the client 70 and a half or older has money in a traditional IRA, if the distribution is made directly from the IRA to charity, maximum of $100,000 per year may be distributed to charity, and it counts towards the required minimum distribution amount. One of the really nice things about this is it can keep the income of the client lower, because that income is not reported to the client. There's no income tax deduction that they also get as well. But by keeping their modified adjusted gross income lower, it's going to typically lower their Medicare premiums for somebody who's got significant income. So this is your wealthier clients who are giving money to charity every year. You want to make sure that they try to do that if they're 70 and a half or over out of their traditional IRA accounts. Wonderful planning. Now, if they're going to leave assets to charity when they die, all right, well, you'd like to have them get assets that don't get a stepped up basis. Now, IRA assets, traditional IRAs, do not get a stepped up basis. Non-qualified annuities don't get a 401k plans as well, traditional 401ks or 403bs through savings plan accounts of that nature. So basically, you want to, if you're leaving money to charity, you want to do it with out of one of these accounts. And that's going to take some, because you do this by beneficiary designations. You might say, well, 20% of this account goes to charity when I die. You don't know exactly what the account is, what the amount in the account is, but you're typically leaving a percentage to a charity. You're going to have to keep track of that and kind of revisit that every year with the client to make sure as the account values change, that that's the amount they want to go to charity, or the approximate amount. Another way of doing it is just set up a separate account and have that IRA account go to a separate charity, go to a particular charity. So well, that's the end for this presentation. Thank you.